The Federal and Velevin Hypermarket jointly present the Thuthukudi Marathon 2024 to raise awareness on drug abuse. The event is co-presented by Edison Cardio Care Center, Tiruchendur, powered by L. Anand Jewelry and St. Mother Teresa Engineering College, Thuthukudi.
The Supreme Court has given a landmark judgment on reservation for the SC communities. States can now subcategorize them to grant them separate quotas on reservation. We are now joined by Mr. Mehmood Pracha, an advocate and founder of Mission Save Constitution, to discuss what this really means. Mr. Pasha, welcome to the Federal. So my first question is, given that every SC communities has been historically oppressed, is it too early to subcategorize them? How do you view this judgment?
This is seemingly, it might seem to be a good judgment from one angle. But this is one of the biggest attack on Indian Constitution. And I'm saying this with full sense of responsibility. Because the fact remains, if a 7-judge judgment is being given, a holistic picture should have been taken into consideration, which has not happened. Rather, a divisive judgment has been given, which will only create a tussle between various communities of the scheduled caste. And the fact remains that not more than 7 or 8% of the out of 15% of the reserved percentage, which is a reserved percentage for scheduled caste, and 7.5%, which is reserved for scheduled tribe. It has never been fulfilled in the entire history of reservation. So the fault lies somewhere else. By the use of the nefarious concepts like not found suitable, scheduled caste and scheduled tribe communities are kept out of the benefits of reservation, and that's happening under the nose of Supreme Court and all the high courts, the governments, and everyone. No judgment has come in favor of that. No judgment has come to protect the scheduled caste and scheduled tribe from this atrocity, which I call an atrocity only, because that's taking away the benefits of Constitution from the scheduled caste community and scheduled tribe community, while showing to the world that we are such benevolent country that we are giving so much to them. So this is adding insult to injury. Supreme Court has not gone into that aspect at all. That is the worst part of this judgment. Secondly, when this being the case, if the government or the Supreme Court is interested in protecting the rights of scheduled caste and scheduled tribes, enhance the percentage, enhance it from 15% to 20% and 25%. Who's stopping you? They have the first, scheduled caste and scheduled tribe people have the first right on the resources of this country. Nobody can deny that. Anybody who denies that is against the Constitution, is against the very concept of equality and justice, which the father of the Constitution, Baba Dr. Bhimrao Ambedkar, and the Constitution itself provides for the weaker sections of this country. So instead of increasing the percentage to take care of the backwardness of the community, these two communities, you have created a rift between the communities. Now what will happen is, another aspect of this is that they have introduced the concept of creamy layer, which is per se anti-constitutional, and it is dehors the Constitution. I mean, Constitution does not envisage anything called creamy layer. It does not. So the concept of creamy layer for OBC was bad, against the Constitution, and that time also we had warned the people that this is going to be further extended for scheduled caste and scheduled tribe, and this is what has happened.
Okay.
This is, and I say this with full sense of responsibility, not even one judgment of the Supreme Court or any of the high courts in the country has come which does a holistic or a wholesome justice to the weaker communities of this country, and that includes not just the scheduled caste, scheduled tribe, but Muslim, Sikh, Christian, Baud, and women and children and handicapped and the poor of this country. Not even one judgment. So that is the state of affairs. Now, what is going to happen because of the creamy layer and the mixture of division? What is going to happen is, as it is, there are not enough candidates to fulfill or rather fill 15% seats or 7.5% seats. What is now going to happen is that whoever is able to cross that barrier will not be able to sit in these exams as a scheduled caste or as a scheduled tribe. So there will be a further reduction of representation in all the places which are available under the scheme of reservation. Second, there will be absolutely, even now there is no one in the higher echelons of the society, be it judiciary, be it bureaucracy, be it business, anywhere in the higher echelons, there is no one from these communities. Now, whatever little a minuscule minority is there, that also will vanish. So it is in effect bringing back the Manusmriti. I would say this is one of the biggest steps to bring back Manusmriti into our system, something which the BJP failed by not securing 400 seats. They are doing it indirectly, and that's what is happening. This is how the entire case was argued before the Supreme Court, and this is the result which we have got.
So, since you have spoken about Manusmriti, can this judgment be seen as an organic transformation of taking reservation away from historical backwardness to economical backwardness, something that BJP RSS combined has been politically rooted for a long time?
Step. It is a direct, open step. It is a declaration that Constitution is going to be violated. Now, please tell me, if there is one example where the 15% was exhausted fully or 7.5% was exhausted fully, then I can understand there is a need for division. Then I can understand that sub-classification is required because this community is lagged behind. Seats are vacant. Seats are vacant for any community to fill it or to fill it. Yet this mischief of a judgment is facing us today. And I think there should be a huge April 2nd, 2018 like campaign or a protest which should start. And I think I am giving a call from your channel also, and I've given this call from all the other places which have taken my interview on this subject, that the time has come now when we should come and hit the streets and we should have a peaceful protest against this judgment, and we should make this government bring an ordinance or the law to extinguish this judgment from the face of earth. This is an anti-constitutional judgment. It is a perverse judgment. I cannot and I do not want to say anything more about this judgment.
Okay, and one more thing, sir. Is the discussion on reservation is slowly shifting towards economical aspect of it rather than the historical?
Where is the word economical? Economic there in the Constitution? That is what I am asking in the context of reservation. It's socially and educationally backwardness. That is the main reason. That is the only reason. These two are the only two reasons which have been envisaged as the reasons for granting reservation to any community. Economic criteria was never there, and this subject was discussed threadbare during the Constitutional Assembly debates. So, and Supreme Court upholds that economic reservation. This very Supreme Court has upheld. Can we call that judgment a fair judgment? No, I cannot bring about myself to call that judgment or this judgment as a fair judgment. These two judgments are perverse judgments. They are anti-constitutional. They are anti-scheduled caste, scheduled tribe judgment. And I think more needs to be done to sensitize the honorable judges of the Supreme Court and High Courts. More needs to be done to take action against such judgments.
So actually the petitioners had not themselves prayed for a decision on creamy layer, but the SCS nonetheless talked about it. Are references in this judgment regarding to creamy layer actionable or merely meant to serve as directions for future policy formulation?
See, I have said in the beginning also, anything that is in favor of the scheduled caste, scheduled tribe, women, Muslim, Sikh, Christian, Baud, children, poor people will not be implemented. That has been the scheme of things in our country, because this Manuvadi mindset controlled system which we are having. So the smallest of opportunity to crush any right, to extinguish any right or any smallest of benefit will be grabbed and implemented in its more than what is written or what has been expressed in the Supreme Court judgment. The Manuvadi mindset is looking for such opportunities. SC/ST Act, Prevention of Atrocities Act, that is, it's not implemented even 10% across the country. That's a very responsible statement I'm making. The provisions of SC/ST Prevention of Atrocities Act are not implemented even 10%, despite the fact that this very Supreme Court has observed that state governments are guilty of flouting the provisions of SC/ST Act. Had it been the other way around, and will it be the other way around, then every officer, every Manuvadi officer will jump to quote that judgment, that Supreme Court has said this, that there has to be an inquiry. Recently, a series of judgments have come who have, which judgments have actually diluted the Scheduled Caste and Scheduled Tribe Act, Prevention of Atrocities Act. That everybody is implementing. Everybody knows, even a police officer down to the smallest of village will know this. How not to give anything to the Scheduled Caste and Scheduled Tribe. And if there is a judgment which is in favor, that will not be, that will be ignored and nobody will take any action. That has been the basic formula which is working in our country and which has to be crushed with a very heavy hand. That's what I feel.
Okay. So
the people who filed this petition were under the impression that the communities which are further or who have lagged behind in getting the benefits of reservation will get something. And an opportunity has been grabbed. I would say, I cannot use any other words. For a lack of a better expression, I would say an opportunity has been grabbed to introduce the concept of creamy layer even in the Scheduled Caste and Scheduled Tribe reservation, which is the worst thing to be criticized about this judgment. And I think people should rise up. People of conscience, people who think that Constitution is supreme, should rise against this judgment, lock, stock, and barrel, with full strength in a peaceful manner. That is what I would suggest and recommend for anyone who is an Ambedkarite.
Okay. So Justice Pankaj Mittal mentioned that reservation should be limited to the first generation. How do you see this? How might this statement impact the future view of reservation policies in India?
Is that so in AWS reservation? Is that so? I mean, what more can I say? I will not comment upon the honorable judge because our system makes him honorable. But this judgment is to be criticized in the strongest of words. It is a bad judgment in letter, in spirit. It is a judgment which actually deceives the people who are most downtrodden. It will not give anyone anything. Rather, it will take everything from everyone belonging to Scheduled Caste and Scheduled Tribe. The question is, what is the basic reason of affirmative action? That a person who has been historically suppressed, who belongs to communities or groups who have been historically and suppressed because of their belonging to a particular group or a particular community, they have to be brought up. This is the basic concept. If our country is failing in doing that, this noble goal of the Constitution, of Baba Saheb's Constitution, then we should try more, or rather say, raise our hands and this is enough, we've done enough, even if you are a second generation person, because first generation has got it, we will not give you even though you deserve it. Should that be the attitude or the approach? Are you doing a favor? It is as if something is being granted. This is the mindset which has to change. This is the Manuvadi mindset which has to change. It is not something to give. It is their right until the time they deserve it. They have to be. You cannot put conditions on affirmative action. The only criteria should be that person has crossed that barrier, that iron curtain, that iron wall, which prevents him, that iron roof, which prevents him from breathing freely in the world. Unless that wall, that roof is broken, he has to be protected. He has to be given all the affirmative actions which he deserves. See, if somebody is become capable, he will automatically cross the barrier. And in any competitive exam, he will top the exam, or he will come in general category. He will qualify in general category. That is the criteria. Now he does not require. So there is an inbuilt system, which I think Supreme Court and the government is going to break even that. Right now, if somebody belongs to scheduled caste or scheduled tribe, he secures marks in any examination or in any field which make him cross the qualifying marks for a general category person. He automatically has come out of that reservation category. He no longer requires that reservation. That is the inbuilt system. You cannot prevent anyone who's not secured the marks to qualify as a general category person. You cannot deprive him. That is the law, and that should be the law, and that is justice. Everything else is injustice. Everything else is injustice of the biggest order.
So, but the court has highlighted there should be a need for empirical data to justify these subquotas. What exactly does this data record specify? What does it take for a specific community to receive such a subquota?
So, this empirical data, Supreme Court had said this from the time of Indira Sahni's. How many years have passed? Today, 30 years have passed, almost 35 years have passed. That empirical data will never come. And Supreme Court will show no hurry to collect that empirical data. Our governments will not show any hurry to collect that data, which is a precondition for granting more people reservation. I mean, then you are forced to say that it's a fair system. Can you call this a fair system? Can you call these judgments fair judgments? No, you cannot. Where is the empirical data? You will not hold the caste census. Supreme Court will not show any hurry, any urgency, or will not put any condition that this empirical data should come in next 6 months, 6 years, 60 years, 600 years, 6,000 years. That Supreme Court will not specify in the judgments. So if you want these judgments to be called as a just and equitable justice, sorry, I cannot bring myself to call them just judgments.
So you say socioeconomic caste census is first required to showcase what this empirical data really means, right?
If that is a precondition, the Supreme Court in various judgments says this is a precondition for granting, again that word, for granting the benefits of reservation or affirmative action, then that is the first thing. The precondition has to be satisfied in a time frame or not. That precondition will never be fulfilled. And judgments after judgments will keep coming that because that empirical data is not there, so therefore there is no need to give. Is this fair? Is this fair?
If the implementation requires for caste census to be conducted, how can this judgment benefit people if center doesn't agree on conducting the census?
As I said,
is it a loop? Is it a loop?
No. You can call it a loop or whatever. But if I have to be candid and truthful, I have to say this judgment will achieve nothing. This judgment will only achieve one thing. And that is, there will be a clash between various communities of scheduled caste. There will be a clash between various communities of scheduled tribe. That is going to be the only outcome of this. Nobody is going to benefit out of this. Everybody is going to be harmed. If government or the judgment was really wanting to achieve the pious goals, as it says that everyone should have representation as per the population, percentage of their population, then something else needs to be done. First thing would be to exhaust the backlog. Has any judgment come to clear the backlog? There will be no requirement for anything. Backlog is such a huge, is in such huge numbers that everybody will be adjusted. For that, nobody will work. Nobody will show any urgency to fill the backlog. Is this fair? Do people think we are fools?
The Federal and Velevin Hypermarket jointly present the Thoothukudi Marathon 2024 to raise awareness on drug abuse. The event is co-presented by Edison Cardio Care Center, Tiruchendur, powered by L. Anand Jewelry and Saint Mother Teresa Engineering College, Thoothukudi.